Hello and welcome to Calm the Pharm podcast, where pharmacy business meets legal wisdom, minus the headache. In each episode, we share practical legal tips and real-life examples to help you run your pharmacy with confidence. I'm your host, Sarah Stoddart. Thanks very much for joining us. Today on the podcast, we're talking about what happens if your landlord sells the property in which your pharmacy business operates. So we've spoken previously about the fact that most businesses are leased premises and the owner of that premises is the landlord. Now, the landlord leases to you, but they are also business people and they are entitled to deal with the land or the building in which your pharmacy is located. And sometimes that does mean that the property or the building or the land, however you want to refer to it, is sold. When, as a tenant, you find out that the building, property, land has been sold, it can make you feel a little nervous. What is going to happen to your lease? What is the new landlord going to be like? Are you going to get on with them? Are you going to work well together? Are they going to come in and want to do a heap of work, perhaps demolish the premises? There's lots of thoughts that goes through a business owner's mind when this happens. Today, though, I'm going to talk to you about how you can protect your pharmacy's location, particularly in circumstances where the property is sold. First and foremost, the best way that you can protect your lease and ensure that it is recognised by third parties and the buyer of the land is to make sure it is registered on title. So where a lease is registered on title, that means that a title search of the land will show that the lease is there, and that enables everyone to know it's there and for your rights under that document to be recognised. When the land is sold, the title changes from the current landlord to the new landlord, but your lease doesn't change. It remains on title. So that is the best way to protect your interests. If for whatever reason you're unable to register your lease, maybe that's because it's for less than 3 years, or maybe that's because a survey plan needs to be done, you don't want to pay the expenses of that, or perhaps it's something you've just not got around to and now the documentation won't allow you to do it, maybe because there's been changes to it or it's not in registrable form. The next thing you can look to do is actually have a term incorporated into your lease which deals with what happens on the sale of the land. Now, at this point, it might be worthwhile pausing the podcast and pulling out a copy of your existing lease to see if you have a clause in your lease that is common in leases that says that if the landlord or the lessor, depending on how they're referred to, sells the land or the property, they are required to have the new owner, the buyer, enter into a deed or other similar document to recognise the terms of the lease. Now, this clause means that the landlord can't sell the land unless they've entered into an agreement with the new buyer that the new buyer will recognise the lease and be bound by the terms of the lease once they are the owner, as if they had been named as the owner of the premises to start with. So you can certainly look to see if you've got that clause in your lease, and if you don't, perhaps you want to try and get it incorporated into your lease now or at the next appropriate time that your lease is negotiated. Another thing you can look at doing, and this doesn't interest everyone, but it interests many people, is to try and have a clause incorporated into your lease that gives you the first right to purchase the property if the landlord decides to sell it. So that's a first right of refusal clause, or it might be a first and last right of refusal clause. But that means if the landlord makes the decision to sell the property, they have to come to you first, see if you're interested in buying it. That then would give you an opportunity to purchase the property and, of course, retain control of the premises, as well as have an investment property under your belt as well. So that's another option. Regardless of how you go about protecting your interests, One of the other really good things you can do is to make sure you have sufficient tenure. So to make sure that the term of your lease is long enough to protect you and your business. Now, of course, you don't necessarily want to sign a 10 or 20-year lease because business can be volatile and things do happen, and committing to a lease for that period of time can be quite daunting. However, what you could do, for example, is enter into a 5-year lease with 3 or 4 5-year options. That way you get the benefit of that 20-year period, but you have to make the decision every 5 years whether you want to continue for another 5 years. So really, as a tenant, you're looking at the lease in 5-year periods, but from the landlord's perspective, they need to honour that lease for a period of 20 odd years. So there's some options to think about in how you can protect your lease, particularly in circumstances where the land is sold. If you've got any questions or suggestions for future podcasts, please reach out. I love hearing from listeners with feedback. Of course, don't forget to subscribe to the podcast and shoot me a review via whatever channel you're listening to. Thanks, and speak to you soon.